Hi, I'm Charles Reed with GetPayroll. With me today is Matt Gizzo, an attorney here in Dallas. We're here to discuss some of the things that are going on with reopening businesses. Matt, you want to tell them a little bit about yourself?
Yeah, so I'm an attorney for Ogletree Deakins. We are a firm of about 900 attorneys with over 55 offices, both here in the U.S. and abroad. And we represent employers and businesses on any matter of labor and employment issues that arise.
All right, good. Well, there's a lot of things going on. Many states are now beginning to open up. What does that mean for employers?
Well, it means a couple different things, Charles. And first, let me say thank you for having me and doing this. I'm glad to get the opportunity to speak with you and your clients. So one thing we're seeing these reopen orders. Coming along with them is certain guidance and safety requirements that employers need to implement.
Okay.
So, along those lines, some of the guidance are recommended, others are required, and it spans the gamut from if you're a retail establishment, maybe you need plexiglass barriers, you need to have associates wearing face coverings, you need to be cleaning high-touch surface areas, but there are a number of things you need to look for in order to be fully compliant with the law.
Okay.
So, Charles, I know we're seeing a lot of employees that don't want to return to work for various reasons. For example, they're receiving much more in unemployment benefits than they normally would expect to receive, and maybe more than they even get paid. Do you have any insight on that and how that be handled?
We're finding that's a problem. A number of our employers have found their employees don't want to return to work because the extra $600 a week from the federal government for unemployment on top of the state gives them more income than they were making before. So if your employee doesn't want to return to work and doesn't have an underlying COVID reason, the moment they say they're not eligible, they're not going to return to work, they're no longer eligible for that federal $600. The state is up to the state, but the federal goes away. So if you report them to the unemployment people, they will lose that $600. If they have an underlying COVID reason, a child at home, they're sick, they're taking care of someone sick, you can't force them to come back to work. But it will not count against you about your PPP, your payroll protection loan. That won't count against you for not having them back.
Right. And just to add on what Charles is saying, I know something that we're seeing in that realm is individuals don't want to come back because of this enhanced unemployment, but employers need to know how to handle that situation, right? Where you need to send out a notice to those employees, letting them know you have an obligation as an employer to inform the Unemployment Commission.
Yes.
Now, one thing we're seeing, though, is, for instance, the TWC has been inundated with claims. So it's going to be tough to reach them right now. So what we're telling employers is be a little patient. We anticipate that a lot of this might get sorted out on the back end. They'll go after overpayments, and ultimately it'll get figured out, but it might take some time. But we are telling clients to be cautious, right? You do want to seem empathetic and sympathize with people that do have a general fear of returning to work. But whether it's a general fear or just the fact that they want enhanced unemployment, those issues alone are not a reason not to return.
What about high-risk individuals that don't want to return to work?
So this presents a little bit more of it's a little bit more complicated, right? Because in that instance, you have to take into consideration the fact that they are high-risk individuals. That could be for any number of reasons. I think we're seeing some different comorbidities, like diabetes is a big one that's popping up. Obviously, people over the age of 65 and people with high blood pressure or some other sort of respiratory illness. In that instance, under the American with Disabilities Act, you have an obligation to engage in the interactive process with that employee and try to determine is there an accommodation that we can make for them. So for instance, you've seen a lot of companies have moved to telework, which lots of times will be an accommodation for a request like that. But it may not always be an accommodation, so you'd have to figure out, are there other things that we can do? But always being mindful of whether someone's teleworking or not, they still have an expectation that they're performing their job and their duties as anticipated. So you definitely have to be mindful of that, and at times it makes sense to contact legal advice or contact your counsel and discuss with them how best to kind of navigate these waters.
Sure.
So, what do you expect to happen with federal unemployment and state unemployment, Charles?
Oh, that's going to be a disaster for businesses. I was looking at the numbers today. Just the $600 a week, over 33 million people, over just through July 31st, if they don't extend it, is somewhere on the order of $250 million or $333 million, all of which the states are going to want to recoup. So I expect unemployment insurance rates to go through the roof. I expect probably every state to be on the FUTA credit, where they've had to borrow from the Labor Department to pay their unemployment, and so we're going to have to pay that back. That normally comes at the end of the year as a surprise to everybody, that they have this, that they have to have withheld and pay in for a FUTA credit that they weren't expecting. They may know their unemployment rate, and it may have jumped from 0.27 to 3.5% and multiplied their unemployment expense 10 times, but they won't expect the FUTA credit on top of it.
Right.
And that's going to happen.
Right. And I think you're right. I mean, it's a mess, and I think it will get sorted out, but it's something for definitely employers to be aware of.
Matt, how do employers handle things like temperature checks, symptom screening, with the privacy rights that those things impact?
So, couple issues here. This has kind of become a hot button issue, especially given with the COVID crisis, right? So in normal times, under the law, a temperature check of that sort or even symptom screening would be considered a medical evaluation that you actually have to be a medical professional to perform. So as an employer, you really would not be able to do that. Things have loosened during the COVID crisis because we want to try to make sure that all environments are safe. But that's not without some risk to employers about how they actually perform these temperature checks and screens. Actually, as a firm, we've prepared a temperature check screening guidance that we're actually providing to some of our clients for a small fee that outlines some of the things to be aware of and the best practices for doing that. One thing with respect to privacy issues, we are advising clients to be aware that if they log this information, right, some state reopen orders are actually requiring that this information be logged.
Wow.
If you have to log the information, then you have to keep it in a separate file, right, where it's confidential, and you have an obligation to maintain the privacy of those records. Another option, though, if you want to mitigate some of the concerns regarding data privacy, is you could perform a screen but not actually log the results. So you could take someone's temperature, you can advise them, maybe they can't come into your facility, or with employees they have to go home, but you're not actually logging that information on a sheet that then would implicate some data privacy issues. But, we're seeing a number of different things at play. Some of the temperature screening devices are actually infrared devices, which could call into play some biometric data issues, which there's separate laws that apply to that. So there's a couple of, pitfalls to be aware of, and it's not something that should be taken lightly. So, Charles, what about the Form 7200 for employee retention credits? What needs to happen with those?
Well, the Form 7200 allows you, if you are doing the retention credit, not the credit where you don't have to pay in your employer's share of employment taxes, but where you're paying payroll on the retention credit that was passed as part of the CARE Act. If you're doing that, then you can get a credit for up to half of that you're paying for eligible wages for eligible employees. And there's lots of details. But if you do that, and it exceeds the amount of deposits you would otherwise make for taxes, you can file a 7200, Form 7200, with the IRS asking for an advance credit. There's some problems. First of all, the only way to file it is via fax. Well, as we know, and as I was talking to the IRS, I'm part of the Internal Revenue Service Advisory Council. We had the commissioner on here a couple of weeks ago with a number of the other BOD commissioners that do every different areas, and they had 9.5 million pieces of mail they hadn't opened. That was 2 weeks ago. It's probably 11 or 12 million now. They are way short of people. They had tried to bring in some volunteers to start opening the mail and so on. They figured they needed 1,200 volunteers they were going to pay more money to. They got 300. So they're way short everywhere. Now, you can go ahead and file the 7,200, literally every payroll if you want, but I don't expect much coming back from that anytime soon.
Right.
So if it doesn't exceed your deposits, just don't make your deposits and work it all out on your 941. If it exceeds your deposits, go ahead and file the 7,200 if you want, but don't figure you're going to get the money next week.
Be patient.
Very patient, because it's going to be a long, involved process for the IRS, who was not the fastest responding organization to start with, to get back to where they were,
right,
let alone get ahead of the curve.
And I think that's something that I think everybody has to be cognizant of at this time, is things are moving quickly, but they're still moving very slow at the same time, and that we need to be patient.
What are some of the other areas where you anticipate potential litigation, legal issues, and legal problems stemming from the COVID-19 crisis?
So there's a couple of different areas, and I'll highlight a few of them. One is, as we know, a lot of people have been furloughed, as we see from the spike in unemployment. Part of the equation is, how do we return those people to work now? And many businesses are grappling with, do we return everybody or do we return some and not all? Returning everybody that's kind of the easier of the two scenarios. But if you're going to return some and not all, you can run into issues, particularly where it pertains to discrimination. How are you choosing who comes back? And, this is going to be critical. And actually, my firm has prepared a return to work guide that highlights certain issues like this and helps employers walk through the assessment of what to consider when recalling employees, additional policies you have to have in place. But I think discrimination is one thing that we're going to see. So you want to make sure that you're finding some sort of objective criteria rather than subjective criteria for recalling people. For instance, objective would be seniority. You're going to start with the most senior people and you'll bring them back in that way. Subjective would just be, hey, I like that person, that's why I'm recalling them. That's where you're going to get into trouble. And we caution employers, even when you talk about some performance components, there's a level of subjectivity there. So people
Absolutely.
like to rely on performance and productivity, but you need to know there's a level of subjectivity built in as to who that person's reviewer was or their manager was,
Yes.
and the reason that they received those particular performance reviews. So that's something to be mindful of. We're also anticipating some wage and hour issues. So for instance, if you have to have an employer get screened before they come into work, is that payable time? And that invokes kind of a state-by-state analysis. Some states might say it's de minimis. Others might actually say that's time that has to be compensated for. You also run into the issue of telework. It gets much harder to kind of police the time that employees are spending on actually performing work. And if you're not diligent about how you do that, there's a chance you could be exposed to wage and hour.
Absolutely.
The other big one I'd highlight is probably disability discrimination type issues like we were talking about before. How do you accommodate a high-risk individual? Or what we're seeing too, a lot of places are requiring masks. What if somebody can't wear a mask for a certain reason? How do you accommodate that? One thing we're suggesting is maybe you can't do a face mask, but how about a face shield, which we're seeing pop up a lot more now.
I've seen some of those.
So if I have a client that asks, what do I do with my company's share of Social Security taxes? How do I defer that? What are my options there?
Currently, if you're not under the PPP, you can defer the employer's share of taxes for FICA and Medicare literally till next year and the following year. It will be due December 31 of 2021, and the other half due December 31, 2022. Now, if you've gotten your PPP, you can't defer those taxes. If you had taxes you paid prior to getting your PPP, you can defer those taxes. We're not heavily recommending it to our clients because in reality, it's a very small part of your overall payroll. The complexity of tracking that and reporting it and paying it in a lump sum or half of it in a lump sum a year and a half from now, a lot of people are going to miss it. And it's going to be another big bill that you're going to have to pay immediately right then. And if you're not prepared for it, you haven't put the money away, it's not going to get done, and then there's going to be penalties and interest. So for our clients, if you need it, if it's critical for you staying in business, defer them and don't pay them and worry about it in the future. We'll track them for you in the payroll system. If you don't need to, it's not that big of a deal. It's not like 50% of what you're paying people. It's, 7.65%. If you can live without that, do it.
So I think you said something interesting there is you said that you can actually track that for them. So if a client was in dire straits and needed that money now to operate, is that something that you're able to do, track it on your payroll system?
Yeah, absolutely. We can track that and report that for them. We'll actually set it up so we don't make the deposits. We don't pull the money from their account.
Right.
It actually stays with them. They never see it go anywhere. It stays in their bank account. It doesn't come and flow through us to the service. It doesn't get deposited, and we track that for them so we can tell them at the end of next year how much they have to pay, and the following year how much they have to pay, and if necessary, we'll draft it and pay it for them electronically.
So Charles, I have a number of clients that are asking me questions about PPP loans, and they're very concerned about making sure that these get forgiven. I'm hoping you have a little bit of insight on that.
Well, there's some problems with the PPP program at the moment. Congress obviously designed that to be a forgivable loan. If you use that for payroll and up to 25% for other things such as rent and utilities, their intent, I think, was that it be forgiven. Well, they didn't consult with the IRS and lawyers concerning tax-exempt income. And the standard law is if you have income that's exempt from taxes, the expenses for that income aren't deductible.
Right.
Just like if you're buying tax-exempt municipal bonds, your investment expenses for that are not deductible expenses.
Right.
So the IRS came out with guidance that said, yes, the loan is not taxable income, but the expenses you use it for are no longer tax deductions, effectively making it taxable income. Now, there is a push in Congress right now to correct that and make it exempt from income taxes. And I think that will happen, but it's the will of Congress, and the Democrats may want to hold it hostage to something else, or the Republicans the same way.
Right.
I don't know. I've quit trying to guess the intent of Congress and its will many years ago.
As we all have.
So at the moment, no, it's effectively taxable income. Call your congressman if you're really concerned. That's all I can suggest, because it's totally in the hands of Congress. The IRS has said it's taxable income effectively now. So who knows?
That's the case with a lot of this new litigation, new legislation.
And that's something we're finding. And for all of my clients and all of yours, you got to keep up with this thing. The regulations change constantly. As I told people in a blog not too long ago, I don't expect the final regulations to be in place for 2 years, and I don't expect the court cases that will be brought up because of the regulations will be solved for at least 5 full years. So it's going to be in contention for many, many, many cycles to come.
And I think that's spot on. I think you could say the same even about the litigation we're seeing on our end. It's starting to trickle in now, but you're really not going to see the wave of this until probably the end of the year. And then you can imagine just how long your average court case takes before you get some real guidance as to how this is all going to play out. And it's going to take time. It's going to take at least 5 years before we really get a good sense of that.
Yeah, I'm sure your people like mine are constantly updating and reviewing the things because literally things change day to day.
And I know I try to stay up with everything that you guys post on LinkedIn and on your website to stay informed. And I know that our firm is doing the same. Aside from some of the services and products that we offer for a fee, we have a whole slate of free advice and webinars and different things that people could access to stay informed, and recommend that you do it.
Yeah, and as we try to send out to our clients, as things change, but it is an ongoing process. It's going to be a long time before it gets settled.
I say it's the dog on the treadmill chasing the hanging bacon, right? He's never going to get there because there's just no way, but we'll try.
Yep, absolutely. Well, Matt, it was good to have you here. I appreciate it. And if you would give everybody your contact information.
Yeah, so Charles, first off, thank you again for having me. Great to get some of your insight on this, because I know lots of my clients have questions that you can answer, so I really appreciate that. I could be reached, my firm again is Ogletree Deakins. My email is matthew.gizzo@ogletree.com, and you could head over to our website too, which is ogletree.com, and you could find me there, and you could also find a whole host of other attorneys in my firm, and yeah.
And for all of my clients, you know where to find us, www.getpayroll.com. We'll be sending out blogs as things change. And my new book is coming out in July, being published by Wiley Press, The Payroll Book. It's a guide for small business and startups. We're taking pre-orders on our website now. You can also find it on thepayrollbook.com. It's available. It'll be out in July. And we look forward to having lots of interested parties looking at that and getting back to us. The COVID stuff won't be in there, I'm sorry, but it'll be on our website. We'll have updates there. Again, Matt, thank you very much for coming.
Thank
and
you,
guys,
Charles.
Stay safe.